Right. Hello and welcome to Win Without Law School. I'm Arizona lawyer Julie Lebenz. Today we are going to talk about how to approach settlement before filing for divorce or legal separation. So we're going to look at how to do what's called the summary consent decree process. This is a new process that became available in 2022. And it simplifies things. There's a lower filing fee. The process is expedited. There's less paperwork. So we'll talk about how to do that. Yet keep in mind that the summary consent decree process is not for everybody. It's only for those couples that are able to sit down, first of all, have sufficient information to negotiate, and then both want to sit down, negotiate, and reach an agreement. If you're at that place, then using this procedure is really a nice new procedure that's available given the lower cost and the simplified procedure. However, not everybody is ready to move to a consent decree this quickly. Some couples need to go through disclosure. Some people, there needs to be some information shared before there's sufficient information to negotiate. So just keep that in mind, that this isn't going to be a fit for everybody, but for those couples that it does work for, this is a really nice option. So in today's lecture, we're going to talk about these 5 steps. First, we're going to talk about how you're going to create your case strategy, which obviously there's much more details on that in the videos in the Win Without Law School members area. There's several videos on creating a case strategy. So you'll do that. And then once you've got your case strategy, then you can make a settlement offer. We're going to talk about how to do that today. Negotiate. If you're able to reach a complete agreement, then you can follow this summary consent decree procedure, and we'll go through how that works. And then once you've filed all the appropriate papers and the 60-day waiting period has transpired, then the judge can sign and file your consent decree. And at that point, you will be divorced or legally separated. Okay, so that's an overview of what we're going to talk about today. Number 1, you want to create your case strategy. So for property division, what is your requested division of the marital assets and debts? That's going to be your property division case strategy. For spousal maintenance, and this is optional, not every case is going to involve spousal maintenance, but if your case does involve spousal maintenance and you're the one requesting it, then what is the amount you're requesting? For how long are you requesting it? And will the spousal maintenance be modifiable or not? Those are all parts of a spousal maintenance request that you'd want to put into your settlement offer. Okay, for legal decision-making, so if you've got a case with minor children, are you requesting sole or joint legal decision-making? For parenting time, what is your proposed year-long parenting plan? And for child support, what is your proposed amount of child support? Who's going to cover medical expenses, and how are you going to divide uncovered medical expenses? So let me correct that. Who's going to cover medical insurance for the minor children? And then how are you going to divide uncovered medical expenses? And what is your proposal to divide the child tax exemptions? So those are all aspects of a child support case strategy. All right, once you know what your positions are on the various issues in your divorce or legal separation case, then you're in a position to make a settlement offer. And again, this is only if you're ready. Some people, for example, if they were in a marriage where there was not an equal exchange of financial information, then they're likely not going to be ready to make a settlement offer at this early stage. In other words, prior to filing. Alternatively, if you have kids in common, but you've got a complicated parenting situation where there's a lot of disagreements, then you might not be ready to resolve your parenting issues at this early stage prior to filing. Also keep in mind that even if you're not ready right now, or let's say you make an offer and you try to negotiate, but the other side's not ready right now, keep in mind that you're going to keep engaging in settlement negotiations throughout your case. It's not something where you try once, and if it doesn't work, you just give up on it. It's an ongoing process where you're constantly trying to get an agreement in place. All right, so if you've been in a marriage where you've had an open exchange of financial information and you're both on equal footing regarding this financial information, and if you have kids, you are able to communicate and work things out about your kids. Maybe you've already got a schedule for a parenting plan that you've been operating under and it's working well. Those are the types of situations where you could be ready to make a settlement offer at this early stage. And if you're going to do that, you got to put your offer in writing. Just talking about it can lead to confusion and can also lead to arguments, because you go to talk about settlement, but then you end up talking about all the reasons why you're getting divorced. It like turns into this blame game of, oh, we wouldn't be here unless you didn't do this, or, and then you're not making any progress. So it can be a lot more effective to put your offer in writing in an email, in a letter. Text is probably not a sufficient format because your offer is going to have a bunch of details. So email, a written letter, then you can, go back and forth in writing and possibly avoid getting stuck in this blame game dialogue. Include an offer deadline. This is going to help you move the dial forward instead of just your offer being left out there and there's no real, need for the other side to respond. If you have a deadline and say my offer expires on this date, then there can be, much more reason for the other side to engage with you. And then you want to share your written offer with the other side, with your spouse, and confirm that they received it. And from there, you can enter into negotiations. How about some tips for writing a settlement letter? Okay, number one, I encourage you to be polite. Making threats or using blame or shame, that doesn't necessarily get the other side feeling really good and wanting to work with you on a resolution. So I suggest you be polite. Also, identify any information you need to gather to make a comprehensive settlement offer. So if there's a piece of information that's missing, identify that and look to gather it, see if you can, so that you can be in a position to make a comprehensive offer. Be as clear and concise as possible. You can possibly have a friend or a family member review your letter to confirm that it's clear and concise. And then explain your next steps if no agreement is reached. So for example, look, my offer expires on March 1st. And if I don't hear from you by that date, or we don't otherwise resolve this, then I'm going to go ahead and file for divorce. And then include a deadline, and that just helps keep things moving forward. Then you're going to convey your written settlement offer via email. I mean, maybe some sort of text attachment, or maybe you could just do a really long text, but I don't know if that's your best format. And then you could mail a letter, or you could hand deliver a letter. You want to confirm your spouse received your offer. In particular, if you're anticipating some games where they're going to, oh, what letter, so you could confirm that. You can also confirm that your spouse is aware of the response deadline. So, hey, did you get my letter? And did you see that it expires on March 1st? I'd like to talk to you about it before then. From there, negotiations can unfold. What do you do if your spouse doesn't respond by your deadline? Well, that's when you can confirm that they received your offer. And you don't have to give up if you get a no or a non-response. Consider asking your spouse to specifically identify what about your offer he or she objects to. And then you can also remind your spouse that if they're not going to engage in negotiations with you now, then you'll proceed with filing papers and you guys can work it out through the court and sometimes that can be helpful in getting the other side to work with you because they don't want to go through court. So, don't stop at no. Try to see if you can work with the other side to specifically identify what they're objecting to, and then see if you can engage in a negotiation on that point, or maybe say, okay, well, if you don't agree to my school parenting schedule, are you on board with the summer schedule? You can start to kind of piece down to what's really in dispute and then engage in negotiations on those points instead of just having this general no. So there's a question here. Would you do an outline like the trial items? I'm guessing you mean an outline of the terms of the settlement offer. The terms of the offer, yes, would need to be included in your letter and should be as clear and concise as possible. So yeah, so the settlement offer should include all of your terms, and if you can put them by number, that's really nice, because then when you are going to negotiate, you can refer to the numbers. Okay, number 1, property division. This was my proposal for the bank accounts. Do you agree? And you can go through each item that way. What if you reach an impasse? So you've negotiated, but you just are at an impasse, for example, about every other week parenting time versus like a 5-2-2 parenting plan. Here's some ideas. Look at the big picture. Are you willing to maybe agree to the other side's request for the parenting plan, but seek some changes on the holiday schedule that are really important to you, or reserve additional vacation time, or something about extracurriculars? Like, is there something that you can negotiate with, some other piece that you haven't used up until this point, that maybe you can identify when you zoom out and look at this from a bigger picture perspective? Next, look at what's in dispute and assess your case. Is it something worth taking to court and fighting over? Do you have a strong position if this were to go to court and be fought over? So look at the big picture and then assess your case and see if maybe you need to be a bit more flexible, or if it's worth digging in and saying, no, I'm not willing to negotiate on this particular point. Look to get creative. Again, is there some other piece of this agreement where you could carve out something that's more important to you in exchange for giving something up to overcome an impasse? So try to get creative if possible. And then also consider requesting mediation. In Yavapai County, for example, you can request a mediation. They have really great mediators. So that is also an option, is to look to get a neutral third party involved and see if they can help you resolve whatever final issues are in dispute. Now, what happens if you reach a complete agreement? So you've created your case strategy, you took that and you put it into a settlement offer, and then you conveyed your settlement offer to your spouse, you guys engaged in negotiations, and you reached a full agreement. Now what? Well, this is where you follow the summary consent decree procedure. So let's look at what forms are involved in filing for the summary consent decree procedure if you have no minor children. So first we'll look at no minor children. You're going to file the confidential sensitive data form with no minor children, the preliminary injunction. One of my numbers got out of order here, but we'll go back to it. Number 4, the notice of rights about health insurance. And then number 3, the notice regarding creditors, the notice of intent to file. And that notice of intent to file is notifying the court that you want to do the summary consent procedure. And then there's the summary consent petition and response, which are one pleading. Your signed consent decree, this gets filed with your summary consent petition and response. Okay, so this is with or without minor children, you'd have these 7 documents. And then if your case involves minor children, there's additional documents. So you're still going to have the confidential sensitive data form, the preliminary injunction, the notice regarding creditors, the notice of rights about health insurance, the notice of intent to file, the summary consent petition and response, the signed consent decree, and then you're going to have these additional forms, the affidavit of minor children, the order and notice to attend parent education class, the parenting plan, the child support worksheet, the child support order, and the current employer information sheet. Now we're going to talk about these forms in more detail. All right, so first we have the confidential sensitive data form. This is what the form looks like for a case without children. You can see up here without children. So you fill this in. It's that straightforward. And then here's the form with children. There's additional information to fill in. As you can see, this is for Maricopa County. I wanted to also show you this form. This is the form from Yavapai County, and a lot of the rural counties use this form. So I wanted to show this as well. This is page 1. You don't file this page with the court, but it does show you the definition of sensitive data. So security numbers, bank account numbers, credit card numbers, or other financial account numbers, and driver's license numbers. So that's what's defined as sensitive data. And then this is the Yavapai County confidential sensitive data form. Now, even if you're outside Maricopa County, you could still use their form, or even if you're outside Yavapai, you could use this form. You're just going to cross out the county and write in the name of the county you're filing in above. Okay, so that's the confidential sensitive data form. Next is the preliminary injunction. This is going to apply whether the case involves kids or not. So the preliminary injunction is an order to both parties. It's effective against the petitioning party upon the filing of the divorce papers. And for this summary consent decree process, it's also going to be effective upon the respondent at the same time, so upon the filing of the papers. And this is an order from the court to both parties, essentially telling them to maintain the status quo. So while the divorce is pending, you can't hide earnings or community property from your spouse. You cannot take out a loan on the community property. You can't sell community property or give it away to someone else unless you have written permission of your spouse. You can't, and let me go back here because there are some exceptions. If you need to transfer property as part of everyday running a business, or if the sale of the community property is necessary to pay for the necessities of life, such as food, shelter, or clothing, or court fees and attorney's fees associated with the divorce. So there's an exception to selling community property, but the best approach is to not sell anything unless you have an agreement from your spouse. Do not harass or bother your spouse or the children. Do not physically abuse or threaten your spouse or the children. Do not take the minor children common to your marriage outside the state of Arizona without a written agreement between you and your spouse or a court order. Do not remove or cause to be removed the party or the minor children from any insurance coverage. So this part really repeats this part, but it's essentially saying, don't sell anything, keep the status quo with property unless you have an agreement with your spouse, which often happens because you could file for divorce and then you and your spouse could agree to separate a joint bank account and, close it and get your own accounts. That is not a violation of the preliminary injunction so long as you're in agreement and do it together. Don't molest, harass, disturb the peace, assault either spouse or any children in common. I think that's pretty self-explanatory, but that's in the order. Don't take any children outside the state of Arizona without written consent of your spouse. Don't remove your spouse or any children from a common insurance policy. These are all parts of the preliminary injunction. Okay, we've got a question. So when the divorce is filed, that is when the community property ends as to the petitioning party. When the divorce is served on the other side, that's when the community property ends for the other side. Now, if you're doing this summary consent decree process, it would apply to both the petitioner and the respondent upon filing. So the papers are filed. If you're doing it together, it applies to both of you. Otherwise, papers are filed, then they're served. It applies to both parties. And the community ends. So at that point, each of you have separate property. Your earnings from that point forward, anything you purchase from that point forward, so long as the divorce ends in a divorce. If you end up withdrawing the divorce, so you agree to reconcile, then at that point, that would all be erased, and everything that transpired while the divorce was pending is back to being deemed as community property. So the divorce has to end in a divorce for the separate property from the date of filing to continue on and remain separate property. Okay, back to the preliminary injunction. So this is just the final page. And then we've got the notice regarding creditors. This is a 2-page document. Essentially what it says is that it's a notice to both parties letting you know that the debts that you incurred during your marriage, you're going to divide those up in your divorce, but the creditors, the people you owe the money to, or the companies you owe the money to, they don't have to follow the terms of your divorce decree because you entered into this contractual agreement with them while you were married. So it just lets you know that you both are still responsible under these debts, even post-divorce. It's just your divorce decree will assign who's going to pay off the debt or what's going to happen with it in the divorce. But as far as the creditor goes, you're both responsible. Now, if the other side is ordered to pay a certain debt and they don't, you could take them to court for non-payment of that debt potentially. But you wouldn't be able to go, to say to the creditor, oh, well, my spouse was supposed to pay that. The creditor doesn't have to follow your decree. So that's what this document notifies the parties of. Also, the notice regarding creditors provides this additional form where you can request a credit report and debt information from a creditor about your spouse. So this form can be helpful. Also, we've got Form 4. This is notice of rights about health insurance. This is telling the parties, look, while the divorce is pending, you can't remove your spouse or your children from a health insurance policy unless you've got an agreement in place. Okay. All right, Form 5. This is called the Notice of Intent to File. So the Notice of Intent to File consent decree for dissolution of non-covenant marriage. So this is explaining that the parties are notifying the court that they intend to proceed using the summary consent decree process. And understand this form may only be used at initial filing with the petition and response document. So very straightforward, but it does require both parties to sign showing that they're in agreement to proceed in this manner. All right, and then we've got the summary consent petition and response. So if you aren't in agreement, then normally when you file for divorce, you just file a petition. But under this new process, if you're doing the summary consent process, then you file the petition and response together. So you just fill this out, information about party A, information about party B, information about your marriage. And then these 4 boxes will need to be checked in order to qualify to get divorced using this form. So you don't have a covenant marriage. A covenant marriage is a religious ceremony when you get married where you promise to God to never get divorced. It's very rare. So most people do not have a covenant marriage. I've had one covenant marriage case in my entire career. So it's extremely rare. Number 2, your marriage is broken beyond repair. We call that irretrievably broken, and there's no hope of reconciliation. You've tried to resolve your problems through conciliation service, or going to conciliation services would not work. And then we do not have minor children together, or we do have minor children and this court has jurisdiction to determine parenting time and authority for legal decision-making over minor children common to the parties, as the children have lived with one of the parents in Arizona for at least the past 6 months. So Arizona has jurisdiction over a child if the child has lived in Arizona for 6 months prior to filing. Then we've got the 90-day requirement. In order for Arizona to have jurisdiction over the divorce, at least one spouse has to have lived in Arizona for the 90 days prior to filing. So you check the boxes here that apply. You'll provide the names, dates of birth, birth dates, and addresses of all living children that are common to the parties. Indicate if one of the parties is pregnant. And then read through these statements and confirm they're true for you. Okay, so you want to understand this process, and then understand there's this 60-day waiting period. So once you file these documents, the court won't file, or the court won't divorce you until 60 days have run. And then the petition and response and attached consent decree constitute the petition for dissolution as well as the required response. Written agreement, joint request to the court. And then this is where the signatures go. And you're going to attach your signed consent decree to your petition. And so you'll want to fill this document out. So you'll fill out all this information, the parties' names. You won't have a case number yet, so you can leave that blank. If you're in a different county, you can change the name of the county to the county you're in. Consent decree. If you're doing a divorce, you'll check this box. If you'd like to do a legal separation, you'll check here. And then with or without minor children. And this is going to be a non-covenant marriage. I did not include the full consent decree form because it's very long, and we'll go over that in detail in some other videos. But access that form and start filling it out, and then watch the other videos to get more information, in particular if you reach a part that you have some questions about. All right, so here's a summary. This is going to be the consent decree forms for no minor children. You're going to have your 7 forms: the confidential sensitive data form, preliminary injunction, notice regarding creditors, notice of rights about health insurance, notice of intent to file, the summary consent, petition and response, and then the signed consent decree will be attached to the summary consent, petition and response. All right, now if your case involves minor children, there's additional forms. So let's look at those. You're also going to file this affidavit regarding minor children. This proves to the court that the court has jurisdiction over your children. So it shows where the children have been living. And so you'll just fill this information out. It's these 3 pages. This document, because it's an affidavit, it is signed before a notary. You can take it to the clerk of the court and sign it before the clerk of the court. That's another option aside from a notary. Okay, if your case involves minor children, there's also this order and notice to attend parent education class. So you're just going to fill out the names of the parties, indicate what kind of case you have, and then that's the form. Here's some more information. During the 60-day waiting period, if your case involves kids, you and your spouse will need to take this parent education class. So follow the instructions in this document. It explains how to sign up for the class. If you're not in Maricopa County, then talk to your court or go to your court's website and access their order to attend parent education class form. Okay, parenting plan. So you will create a parenting plan for cases involving minor children. You will fill this out with your spouse. This will be the agreement you've reached as far as your parenting plan. I did not do this full document here. You can access the full document in the materials below the video. And this document is explained in more detail in some of the other videos. So you'll be able to access that if you have questions about how to fill out this form. Again, if you have a case involving minor children, there's going to be additional forms, and one of the other additional forms is the child support worksheet. So this will be a worksheet that you and your spouse have worked together on, and where you've agreed to all of the terms, you'll agree to each party's gross income and all the other details in here, and there'll be a final child support amount that you're in agreement with. Once you have that child support worksheet done, you can create your child support order. This one obviously is not filled in. If you go to the videos about creating a child support case strategy, you'll get full instructions about how to use the child support Excel spreadsheet to make a child support worksheet, and then how to go from there to make a child support order. So the child support order is these 3 pages. And once you create the initial worksheet, this information auto-populates into this form. And then the judge signs this at the time of your divorce. Okay, the final form for a case involving minor children, if you're using the summary consent decree process, is the current employer information sheet. This is related to child support. This is for the spouse that's going to be paying child support. And this helps get what's called an income withholding order in place, so that the child support payments start coming out of the payer's paycheck and being sent to the clearinghouse and then to the parent that's receiving the child support. Okay, so just as a review for the summary consent decree process with minor children, you're going to draft an e-file. And when you're drafting, you're going to be working with your spouse on drafting these documents. The confidential sensitive data form with minor children, preliminary injunction, notice regarding creditors, notice of rights about health insurance, notice of intent to file, the summary consent petition and response, and attached to that is going to be your signed consent decree, the affidavit of minor children, the order and notice to attend the parent education class, your parenting plan, your child support worksheet, your child support order, and your current employer information sheet. Okay, so we have a question about how to fill out the employer information sheet. So the question was about whether or not you could send an income withholding order to an LLC in order to have taxes taken out. So a couple of things to think about here. So for an LLC, possibly, if the LLC is set up and is running payroll, in other words, the other side is receiving income via payroll through a company that's in an LLC, then yes, that could work, because that's where the income is withheld, is at the payroll level. So the LLC is not protected from child support and alimony. I mean, it's not the LLC that pays, it's the LLC that's being ordered to withhold income from an employee's paycheck when they're issuing payroll, and then to send that withheld money to the child support clearinghouse. So hopefully that's helpful. Okay, so these are all the forms that you would fill out and file if you are doing the summary consent decree process and you have minor children. Okay, so we've got another question, just a second. Okay. So we just had a follow-up question about covenant marriage, just that it doesn't always have to happen in the context of a religious ceremony. However, that's been my experience, because covenant marriage is generally a religious option where you promise to God to never get divorced. So that's my understanding of it. And the thing to keep in mind is that if you have a covenant marriage, there's a different procedure to follow to get divorced. So this particular procedure of the summary consent procedure, this would not apply to a covenant marriage. This is only for non-covenant marriage, which are the majority of marriages, the vast majority. Okay, so what's the procedure? You've done your forms, okay? You've drafted your forms, you've worked with your spouse, you e-file them. Then you wait 60 days. There's a mandatory 60-day waiting period under Arizona law. All right, so you're in your 60 days. And what if during the 60-day waiting period, you or your spouse change your mind and you want to withdraw from this agreement? You don't want to do this consent decree anymore. You want it changed. Well, you need to object before the 60 days runs and before the judge signs your decree. And to object, you would e-file a motion to withdraw from summary consent decree. And let's look at that form. Here it is. So, motion to withdraw from summary consent decree process. You'd fill all of this out and explain why you no longer agree. Fill this out and then e-file this again, ideally prior to the 60 days running and prior to the judge signing off on the decree. So e-file this, serve the other side with a copy by mail. All right, so on the flip side, let's say your 60 days ran and nobody objected. So what happens next? Well, at that point, the judge will sign your decree and enter it, meaning he or she will file it with the court. So give it a date stamp with the court, and copies will be disseminated to both sides. And at that point, you are divorced or legally separated, depending on what your request was. All right, let's go over a summary here of what we talked about. All right, so this is for couples who have a decent line of communication. Everybody has equal access to financial information and information about their children, and you're able to communicate, and both of you want to avoid a long drawn out contested court battle. So number one, if that sounds like you, more or less, you'll want to create a case strategy. If you're ready, if you have sufficient information, make a written offer with a deadline. From there, engage in negotiations. If you're able to reach a complete agreement with your spouse, then follow the summary consent decree procedure. If you or your spouse object during the 60-day waiting period, you could file a motion to withdraw from summary consent decree. On the other hand, if the 60-day waiting period runs and neither party is objected, then upon the judge signing and entering your consent decree, meaning filing it with the court, you're officially divorced or legally separated. So your case would be wrapped up at that point. All right. Thank you so much for participating in today's lecture.